Okay, let's get started. Good afternoon. Lovely to see so many of you here. There's Alan, he's joining us as well.
Good afternoon.
We're going to take you through a seminar this afternoon to deal with hopefully some key aspects of the absolute horrendous crisis that we find ourselves in right now. And it's the objective of this webinar to provide both employers and employees with some guidance, and you as representative of either camp or both camps need to understand the sort of concerns that have been coming to light in very recent times, and in particular we are focusing on a number of different aspects. I'll be dealing with collective consultation, and Alan's going to be dealing with a analysis of business rescue and restructure and insolvency. Those are huge topics, and really these are signposts for you in the way in which you advise your clients. Let me just start with my slides. There's no doubt that there's a gathering storm. I think we're probably already deep within it. But it doesn't quite feel that way, does it? Because of the furlough scheme. The weather's lovely, and I suspect most of you sat there in your shorts this afternoon watching this. I'd like to say I am, but I'm not. The reality, though, is that we have announcement after announcement that suggests that there is a very significant recession coming, if it's not already with us. All the figures that are being announced on the media in terms of performance in the last quarter really only catching the last week or so of March, and it's interesting that already those are showing signs of very significant downturn. This morning's announcement from Rolls-Royce itself was astonishing. It's bizarre, or maybe it's just pure serendipity that ties rather neatly in with the scenario that myself and Alan presented you, which you should have received in advance of this seminar. That focused on flying and aviation, the aviation industry out of Bristol, believe it or not. And of course, the centre, the headquarters for Rolls-Royce engines is here in Filton. And the chief executive, Warren East, made it clear this morning that in his view, no government can extend furlough indefinitely into the future. That has to be right. And what the furlough scheme can't really do is provide a safe haven for millions of employees until such time as this Covid-19 outbreak is over and everyone's back to normal. I just can't see how that can function. And that seems to be the view of the Chancellor, because as you recall from last week, the announcement was quite clear that there would be a requirement for employees who want to remain on the furlough scheme, for employers to make a contribution to that furlough scheme from the 1st of August, with the scheme itself being extended until the end of October. It's a bit of a poison chalice, that announcement, because in our view, the announcement itself must give rise to very significant concerns by employers, whether they're large employers like Rolls-Royce or SMEs, that any element of pay for employees who are not providing profit generating activity is likely to be a cost too far. It's the hope of the government, no doubt, that they can taper this in, and indeed the Guardian's columnist who decided to review this matter in the following day's newspaper suggested that the announcement from Rishi Sunak was an indication the level of state support would gradually taper away. I think that must be right, but we're in the dark at the moment because the clarification of that announcement is going to be made on the 30th of May. And I suspect that lots of employers are already planning for bad news at that point in time. It may well be that many employers can't operate even on a de minimis contribution over and above their existing overheads, which are driving their businesses towards insolvency. So will employers act more quickly than the beginning of August to make those redundancies? Well, obviously, yes, large employers already are. We know from BA and from Rolls-Royce that they're engaging in consultation on a grand scale with the unions. I noticed from this afternoon's announcement at lunchtime in the news that they are unhappy with Rolls-Royce as things currently stand. They consider the announcement to be opportunistic. This rather ties in with one of the slides that you'll hear from Alan about a bit later on, because he was doing this talk, a talk not dissimilar to this about a year ago, and there was very clear evidence of a downturn coming in any event. So the question will remain whether the advent of COVID-19 is such a shock to the system that it might give rise to special circumstances when dealing with a defence to protective awards, and I'll come on to that a bit later. So what are the triggers for collective consultation? And we'll deal with some other aspects in a moment. And I'm really going to focus on those triggers now, because at what point is it that an employer will be liable for failing to consult if it was contemplating making significant redundancy? I can gather one of you must have your mic on, so can I ask you to make sure your mic's all turned off, please? The reality is going to be that we'll need to look at the case law. The case law itself is helpfully summarised in a case in 2015, E. Ivor Hughes and Morris, that related to a private school and a decision made by the governors in the February of 2013 that it would need to make redundancies in the spring unless school attendance numbers improved. In other words, unless paying pupils numbers improved to the point where the school was viable. Well, the question for the tribunal was whether that proposal and that discussion by the governors was itself a point in time at which consultation should have commenced, or alternatively, was the law asking everybody to wait until the statistics came in at the end of April of 2013 that confirmed that those numbers were not going up to the sufficient required amount to save the school. In fact, one of the factors in this case was the consideration that when the governing body in February considered the need for a contingent state of affairs, i.e. contingency that they would need to make those redundancies in April, May, the reality was that they didn't suspect the numbers of kids coming into the school would increase. So they had a contingency that was pretty much clear cut to them. So the EAT reviewed that decision. The tribunal got so much of it right because the tribunal was relying on authority from two different sources, one from the ECJ in the case of Atavan, and the other one, the decision or the judgment of Patrick Elias in UK Coal Mining and National Union of Mine Workers in 2008. The first of those cases gave guidance as to the balance between contemplation and planning. You can sit in bed in the middle of the night and have a light bulb moment and think we might need to make redundancies. Is that going to be the start of consultation obligations, or does it need to be something more concrete? Atavan made three different points. First point, it's the Employment Tribunal will need to make a careful factual assessment of the evolution of the employer's plans in each case. Secondly, the relevant factors for consultations must be known before the duty arises. And thirdly, consultation procedures must be started by the employer once a strategic or commercial decision compelling him to contemplate or plan for collective redundancies has been taken. That combination of words, contemplate or plan, didn't really help, but the general thrust of the decision was quite clear. A commercial decision, a strategic decision. That's precisely what Rolls-Royce have done. They are commencing a period of consultation on a grand scale with the unions because 9,000 workers out of a total of 52.5 globally are going to lose their jobs. They've reached that conclusion that 9,000 people need to go. It gives them a significant saving of about £900 million they've worked out in terms of their overall labour bill, and 1.4 billion in terms of the overall total of savings to be made. So that's a perfect example arising this morning on a grand scale in our own country, and in fact in our own city. So I couldn't have really planned a better example than the one we gave you. Now, looking at the obligations, the best case I think that you could all look at is the most recent decision in 2018 of the Employment Appeal Tribunal. This was Her Honour Judge Jenny Eadie QC, as she then was, as she's now a High Court judge. And the decision in Keeping Kids Company and Smith is of real importance. That case provided for further jurisprudence in respect of the timeline upon which an employer is seized with a duty to consult, and she concluded in that matter, inevitably the assessment required under Section 188 will require the Employment Tribunal to confirm a view on the spectrum between contemplation and proposal. So she sees this as a timeline between an initial contemplation and the fact that a proposal is formed. There'll need to be a lot of evidence about this in any case, and specific guidance about the way in which you'll need to prepare statements, etc., will be needed. That case was fundamentally important because it demonstrated the sort of circumstance that gives rise to the duty to consult, and indeed the kind of shock to the system that might mitigate the impacts of a protective award. In this case, on the 12th of June 2015, the charity Keeping Kids Company, which was a very high profile charity involving some very, very senior people at board level, people like Alan Yentob at the BBC, were involved in this organisation, and they realised after a period of significant financial difficulty earlier in 2015 they needed to make a grant application. The grant application was for £3 million, the government, and it was contingent upon the application making significant, clear-cut cuts to staffing levels and overall budgets in order to make the organisation fit for purpose and leaner. They went so far as to produce detailed plans, 58% reduction in staffing levels, which is 323 people to lose their job. They budgeted that, and they set this out very, very clearly in their proposal to the government. It was that, arguably, that should have been the point in time, or shortly after that, that should have led to consultation, or certainly insufficient time to allow 45 days clear before the decision itself was to be implemented. In fact, what happened was the grant was made on the 29th of July, and that night news broke of some safeguarding issues. The government the next day pulled the plug on the £3 million award, asked for its money back, and the company went immediately into an insolvent position and was liquidated. That secondary element was an enormous shock to the system. The organisation was surviving, it'd been rescued by the existence of this award, and something completely out of the blue destroyed the prospect of it continuing. However, the tribunal concluded rightly, and this is a tribunal decision where the two wingmen, the lay members, were right, and the employment tribunal judge, in the eyes of the EAT at least, was not correct. Certainly in respect of the duty to consult point, concluded that the duty was extant after the consultation, after the bid document was put together. There was a failure to consult prior to the insolvency position had taken place. That itself wasn't something that could be considered other than a matter that related to the mitigation of the scale of the protective award, which the tribunal had fixed at 90 days using the Susie Radin line of thinking. So in every respect, the tribunal was right, save for the fact it erred in law in terms of calculating, in principle, the amount of the protective award that would be due. So this gives you a good example of what is the type of scenario that might impact upon special circumstances, or certainly mitigation of any protective award. But let's not forget, a protective award for a company that's hanging on by its fingernails may be enough in itself to tip it over the edge into insolvency. So are fully formed and approved plans required? The answer is no. I've given you the guidance in respect of the 3 leading cases on this. You're not required either to provide to start collective consultation before all the information is available at section 188.4, and you'll recall from the Act that's a very long list of bits of information that will need to be sent to the union. For example, reasons for proposals, a number of descriptions of employees that will be made redundant, etc. Neither is it required that in a situation where you have a controlling entity such as a council chamber vote in Unison and Leicestershire, that vote needs to be made before the duty kicks in. You do not need shareholder approval in order for the duty to kick in, and neither do you need approval from a parent company. Of course, that's a factor in the scenario that I've given you. So overall, you are seized with the obligation to consult once that plan has been formulated. And let's go back to Patrick Elias's clear indication in the NUM case. That arises where there is a fixed, clear, albeit provisional intention to make collective redundancies. So just looking quickly at this next slide, is 188 triggered by furlough? Answer, I think no, but if you've got any concerns over that, you need to issue your HR1 form to the government. What about the scenario where employers might want to try and reduce the numbers down below the thresholds, whether it be less than 20 or less than 100 employees, by seeking to redeploy members of staff? Evans and Home Office is a 2008 case that says with a mobility clause in place, you can relocate staff in circumstances that might otherwise look like a redundancy. Contrary arguments are in Hardy and Tourism South East, where there was a very significant change in the job descriptions, the location of work, the nature of the work undertaken, and the geography involved that effectively ripped up the old contract, offered a new one in circumstances of restructure, and the EAT had little difficulty concluding that that was a redundancy, and the combined effect of those that were made redundant and those they sought to redeploy was taking the number to 26 and not beneath the threshold of 20, and therefore 188 applied. Just as a matter of illumination, if we go back to the Keeping Kids Company case, in terms of timing for your collective redundancy consultation, some really useful guidance in paragraph 60 of that judgment, where again, Jenny Eady says as follows: requirement to consult in good time does not oblige an employer to start the process immediately when it has formulated the relevant proposal. Rather than the obligation requires the employer to look ahead and realistically assess the timescale required to ensure meaningful consultation can be held, having particular regard to the minimum time periods under section 188A. And that takes me to the next slide, which is the nature of consultation, nature of fair consultation, consultation at a formative stage, and of course that applies potentially under section 98.4 ERA cases as well, adequate information, etc., adequate time in which to respond. All of those matters are matters that may take more time now because of communication issues that are present with regard to furloughing of staff, social distancing, and all the things that underpin our current state of working life. So in terms of determining this consultation in good time, you're going to need to build some more time in. That means fundamentally, doesn't it, if you're going to have a meaningful dialogue and you're proposing to make large numbers of people redundant at the beginning of August, for example, you've got a month and a half before that date to do it. That gives you effectively 2 weeks from the end of May. You've got a month from the end of May if it's less than 100, less than 99. So in those circumstances, build time in and give your clients the advice they need to build time in because of the nature of the difficulties we've got. It's also important that we seek to cooperate with the unions. They're all going to be upset. That's obvious, isn't it? I mean, it's a trite thing to say, but they're going to need to help you as well. You need to have that dialogue. There are aspects that are directly related to the conduct of the employer when it comes to collective consultation. Look at 1885A, that provides that the employer shall allow the appropriate representatives access to the affected employees and shall afford those representatives such accommodation and other facilities as may be appropriate. Nothing could be more perverse really than that at this stage of the game. But again, it's going to need to be something that you need to talk to the unions about. And equally, if you're acting for an individual employee in this scenario, they might need to look at whether or not that was effective. So, special circumstances. I think the best example you can possibly have in modern case law, and there are lots of cases that go back to the mid-70s on this, is the Keeping Kids Company case. That wasn't itself deemed to be a special circumstance because the duty had existed since the bid document was put together. But let's focus on fundamentally the scope argument here. Circumstances cannot be special unless on the facts they make it not reasonably practicable to comply with the duty to consult. So there's nothing about current state of affairs, I think, broadly speaking, that prevents that. The employer's got to be able to demonstrate that the precise circumstances made it impracticable to consult fully. That's been the case law since the 70s. So what is it about insolvency? Insolvency of itself isn't going to be a matter that gives rise to impracticability. That was a ratio being Clarks of Hove and Bakers. And I think that the current state of affairs with COVID-19, with furloughing of staff and downturn and cessation of economic activity on a grand scale is of itself not likely to be considered by the courts to be a special circumstance. What we're looking for is a cliff edge type scenario or a disastrous collapse, such as the happened to the funding in the Keeping Kids Company matter. So unless you've got something like that, you're going to really struggle. That doesn't mean to say that there will not be sudden events in the near future that can cause what would otherwise have been a action towards the process of consultation falling apart. There are likely to be many examples of that, but certainly the broad view, I think, across our sector is that you cannot assume that because it's COVID-19 that's causing all the problems, it's going to give you a get out of jail free card in terms of protective awards. So that's my bit done, pretty much on time. We'd really be grateful for input from you guys later in the afternoon once we get to the Q&A session. We'd really be grateful too, because this is such an uncharted set of circumstances for us, to have feedback and indications what sort of advice you've been giving maybe to your existing client base, and whether or not there are specific areas you'd like specific help from us on. But we'll leave that to the afternoon after Alan's talk. And over to you, Alan. I look forward to hearing the matinee version of your session. Thank you.
Well, thank you, Nick, and indeed thank you everyone for coming along. The participation in these webinars has been truly fantastic. Across this COVID series that we've put together, we've had over 1,000 delegates and indeed a number of frequent flyers, which is also great. It seems that there's never been a period of employment law where we employment lawyers have had to digest so much information in such a short period of time. Indeed, it seems 2010 is now the time of day of the last major employment law update rather than the year. But then again, of course, time seems to have lost all sense of meaning. Let me start by saying what I'm not going to be covering in this part of the talk. I'm not going to deal with the Carluccio's or Debenhams cases or even the role of an administrator in an insolvency situation. That subject has been expertly covered by 4 of our colleagues in a recent webinar. That's available on our website along with the PowerPoints if anyone missed it, and I would certainly recommend you go and take a look. What I'm going to be dealing with is the situations that are facing businesses and what we as lawyers can do if we're acting for them to assist them, and of course if we're acting for employees, what we need to be looking out for. Now, I'm just going to put up a slide that I used in a talk in March 2019. And you'll see here that I posed three things. We are facing another financial crisis, maybe, a recession, quite probably, rising corporate insolvency, definitely. Now, I'm not for a minute suggesting that I'm any great oracle. It was no secret that a recession was on the cards. The purpose of sharing this slide is to highlight that although the COVID pandemic has made financial situation for businesses far more acute and imminent, it hasn't rendered irrelevant some of those underlying problems. Of course, when businesses are in a strong position, when the economy is strong and in an upward movement, businesses can sometimes become a little inefficient. They might take on excess staff, they might have generous supplier terms or even employment contracts. And that's because partly they have the room to be able to do so, partly because, of course, it may well be that they have to offer good commission terms because they need to bring in some talent. As businesses sort of reach the zenith of that economic peak, it's time for them to start reflecting upon those inefficiencies and to try and make changes. But businesses tend not to react as quickly as perhaps they should. And often it leads to a situation where they're forced into making those changes. And this is a fertile scenario for that to happen. So it's worth bearing in mind that, yes, there are going to be unique issues arising from the pandemic, but those pre-existing issues are still present and businesses are going to need to address both. Indeed, now is a perfect time and partly an impetus for businesses to start addressing some of those other underlying issues. So the first part of this section, I'm going to look at restructuring and rescue. And really, they're kind of two parts to the same equation. They're how a business can continue forward. With a restructure, it may be that it gives the business a bit of much needed lift to get them out of a slump. Rescue, of course, tends to look at an external source of assistance, whether it be capital injection or indeed some form of buyout. When we're talking about restructuring, essentially what we're talking about is change. And that change comes in broadly three forms. A business can change what it does, it can change how it does it, and it can change how much of it does. And implementing that change tends to come with three vehicle options, an operational, financial, or corporate. As employment lawyers, there are a number of things that we can do to assist businesses as part of this venture, including things like how they can change terms and conditions, indeed whether they need to consider redundancies. Now, ultimately, those things are bread and butter for us employment lawyers, particularly those that were practicing in 2008 after the last financial crisis, where this became a major part of our practices. The major tricky part of this, of course, is collective consultation, which Nick has covered off in the first part of his talk. The third option is corporate restructuring in a more broader sense, and that's really what I'm going to focus on. Now, I've shared with you the scenario that Nick and I have put together. Nick, of course, was looking at Funair Limited, and I've been dealing with a supplier of Funair, His Nibs Group Limited. HKL provide posh nibbles to a variety of sectors, including the airline industry and the bar and restaurant sector. And of course, because of the position with Funair, they now find themselves in a difficult scenario themselves. And indeed, this is something that we need to be alive to. It's not just the Rolls-Royces or the Carluccios, the Debenhams. We've also heard of Café Rouge and Bella Italia and many other high street and main brand businesses. But it's also the businesses that feed into them. Indeed, as businesses ourselves, of course, if our clients are struggling, that may well have a knock-on effect upon us. And so this ripple effect makes this an issue that's going to affect most sectors, and we're therefore going to need to be looking proactively. And so in the case of HKL, they foresee what's going to happen with Funair Limited and how it's going to affect their business, and they go into these crisis talks. Now, the first part was for them to consider their internal structures to see whether or not they can make redundancies or efficiencies, and they've decided that that's not going to be enough. Well, what they've then moved on to consider is whether they can sell part of their business. Now, HKL were prudent enough that when they entered the bar and restaurant sector, they set up a separate subsidiary that was owned by the group company, and they vested into that subsidiary some IP and some client relationships. But that subsidiary didn't employ any staff. Those employees were employed elsewhere within the business. HKL have now decided that they're going to sell off that subsidiary by way of a share sale. And so the first question is going to be whether or not that's effective. I'm just briefly going to run through the rest of the scenario, and then I'll pick up on some of the themes. After having sold off that subsidiary, HKL then look to the rest of its business, decide that it's insolvent, and attempt a pre-pack administration sale of the business. The administrator expresses some doubt in that, and ultimately HKL consider liquidation. So taking those three parts in turn, let's look first to selling off the subsidiary by way of a share sale. And the starting point is the line of authorities, including that of Henry and London General Transport Services Limited, that identify that a share sale does not give rise to a Tupe transfer. Now, the reason for that is that companies are separate legal entities and separate from not only their shareholders and directors, but their associated companies. And that comes from an old case, Salomon and Salomon and Co. Limited in 1897. What's particularly important is the Brooks and Borough Care Services case, because that identified that this concept of share sales being excluded from Tupe applies even when the scenario was set up to avoid a Tupe scenario. So in the case of Brooks, it involved a local authority, Wigan Metropolitan Borough Council, who had set up Borough Care Services, BCS, as a way of providing care in the community. They later decided that they were going to sell that business to CLS. Now, around this time, a decision of the EAT came out that identified that changes in terms and conditions, even if voluntary and agreed by the workforce, are void for Tupe. And this was something that CLS were keen to do as a way of making that entity viable. And so that put a little bit of a brakes on the sale. What Wigan Council did is, instead of implementing a transfer in the ordinary way, they kept BCS going and then sold the shares to CLS. Now, that would then allow CLS to change the terms and conditions if there has been no Tupe transfer, because the employees would remain employed by BCS throughout. The employees, a group of them, brought a claim and said, look, this essentially is an attempt to avoid Tupe, therefore should be unlawful. There has been a transfer, and accordingly, Tupe prevents those changes to our terms and conditions. But the EAT said, no, this is a share sale. There has been no transfer of undertakings. The employer has been, both before and after the transaction, BCS. And they recognised that the reason that it was done in this way was to avoid Tupe, but nonetheless, they considered that Tupe did not apply. Now, of course, one of the things that employees will almost certainly want to consider is the concept of piercing the corporate veil, to say that in essence, businesses are creating a scenario for their own good. Now, there have been a number of cases, particularly the case of Petrodel Resources Limited and Prest, that have grappled with the concept of piercing the veil. And Prest set up essentially four key components. There has to be an existing legal obligation, liability, or legal restriction. There has to be a deliberate attempt to evade liability or frustrate enforcement. There has to be an interposition of a company to do so, and the absence of any other remedy besides piercing the corporate veil. Now, the first thing is it should be identified that this is something the courts are reluctant to do, and indeed it's very rare that they will do so. And of course, the same principles apply in the tribunal as much as they do in the civil arena. Ultimately, for employment lawyers, the key here is item 2. And you'll note the difference here between the word evade and avoid. Indeed, it's very similar to the concepts we're familiar with in terms of tax. Tax avoidance is something that is permissible in law. Tax evasion is illegal. And indeed, that was something that they grappled with in Brooke. And ultimately, in Brooke, the employees invited the tribunal to pierce the corporate veil, and the tribunal and then the Employment Appeal Tribunal declined. And in the Employment Appeal Tribunal, they identified this principle, and they said that there was no facade. This was not an attempt to conceal the position. And so we can liken this to a sham arrangement where the corporate vehicle has been set up as a sham to conceal the real arrangement. Well, then it may well be that the tribunal would pierce the veil and Tupe may apply. But in the case of Brooke, that was held not to be the case. And I suspect that in the vast majority of situations, that will be true, and piercing the corporate veil is not going to be of assistance. Tupe, however, does have some remedies up its sleeve, and principally the case of Milam and Print Factory London 1991 Limited identifies a concept that might assist employees. And that's where a corporate structure has been set up, but the shareholder, often the group company, acts beyond that of a mere shareholder in their relationship. Now, in the case of Milam, Milam was employed by Company A. Company A was then purchased by Company B as a share sale, and then Company B later transferred the undertaking to Print Factory London at 1991 Limited. Now, throughout that time, Mr. Milam was informed that he was employed by Company A and that Company B had simply acquired their shares. The tribunal and the appeal tribunal, however, concluded that Company B had acted beyond a mere shareholder of Company A, and that had triggered a transfer of Mr. Milam's employment to Company B. And so accordingly, when Company B was then transferred to Print Factory, he then transferred with them. And so what we need to be careful of is that when setting up these group structures, that a shareholder, a group company as a corporate shareholder, doesn't act beyond its powers as a shareholder and therefore potentially trigger a transfer. However, as has been identified in ICAP, Milam is an exceptional case, and although it is good law, on its facts, it's likely to be rare that a tribunal will find that a shareholder has done so. Indeed, shareholders have considerable power in many businesses, and so to be able to act beyond that in itself is likely to be exceptional. But there is, however, one possible pin to burst this balloon. Businesses are going to want to be alive to this. Employees are certainly going to want to be mindful of this. And that is the concept that an employee can be assigned to Company X, even if they are employed by Company Y. Now, that was established by the ECJ in Albron and has been confirmed as being valid UK law in the case of Hyde Housing Association and Hyde. And so this, having reflected UK law, businesses need to be alive to the fact that even though, for example, with HKL, there are no employees within the subsidiary, certainly no employees contracted to the subsidiary, if employees elsewhere in the business are deemed on their facts to be assigned to the subsidiary, well, they will transfer too. Of course, it may well be an HKL scenario. There is a sales team that work pan group, and it may well be that they work, for example, predominantly on this subsidiary. It might then be that the tribunal find that they're assigned to the subsidiary. Of course, we know it's not as simple as apportioning how much time an individual employee works on each subsidiary. It's a question of fact. There are no limitations on the tribunal's fact-finding inquiry in terms of looking at where an employee is assigned. And so ultimately, everything goes into the mix as long as it is a relevant factor. And so we'll need to be alive to that. Now, of course, in the case of HKL, they've set this subsidiary up this way from the outset. And so that is something that they can move forward. But we need to be alive essentially to two things. First, it may well be that the clients that we act for haven't structured their businesses in this way. And if that is the case, the question then arises, can they do so now? Well, of course, the answer is yes, they can. They can set up a subsidiary. They can try and seek to achieve the same structuring as HKL or a similar structuring. But what they need to be mindful of is that if they set up a dormant subsidiary, they're going to want to transfer something in from an existing business. It may well be that they have already an IP that they transfer. It may well be that they have existing client relationships that they want to transfer, unlike HKL, who grew those from the ground up. And the very act of transferring that part into the business may well amount to a transfer of undertakings. So if the group structure is already there, fine, then in which case we need to be alive to the principles we've just been discussing, including Milam. But if they're not there and they're now being set up in this way, we need to be alive to the prospect that if we're not careful in doing so, businesses could trigger a transfer. And so if HKL, for example, hadn't set up this subsidiary, triggered the transfer when they set it up, and then sold that on, it may well be that the purchaser of the subsidiary would take with it some of the employees. I'm now going to move on to the business insolvency part of this talk. And again, we're going to look at the concept in the context of our HKL scenario. But before I do that, I just want to cover some principles in terms of insolvency. Insolvency law sits a little bit on the periphery of our employment law expertise, but it's often worth reminding ourselves, particularly at times like this, when we're likely to engage with it a lot. So the first is the definition of insolvency, sections 123 and 267 of the Insolvency Act 1986, where a business is unable to pay its debts at or above the bankruptcy level, or where it has liabilities that exceeds its assets, taken into account any contingent or prospective liabilities. And insolvency can take a variety of different forms, and I've put up here a slide separating those out as between individuals and companies. Now, it's far beyond the scope of this talk for us to go through each of those, but I'm just going to flag up one point because it's a bit of a terminology tripwire for the unwary, and that's the difference between receivership and administration. One can sometimes encounter receivership being referred to as administrative receivership. That is separate and distinct from administration, so just be careful of that terminology similarity. So looking then to HKL, they've decided that having sold off this subsidiary, the business nonetheless is now insolvent, and they're going to try and sell that business off and achieve as best a possible sale price as it can. Of course, the more flexible the business, the more likely it is they're going to yield a greater purchase price. And when it comes to flexibility, of course, taking with it existing liabilities somewhat impedes that flexibility. And of course, one of the principal liabilities for a business is often its staff, both in terms of its numbers and maybe in terms of the terms and conditions and payment benefits and salary benefits for those employees. So HKL decide that the way they're going to achieve this is to line up a sale first and then bring in an administrator to try and implement that sale, what's often referred to as a pre-pack arrangement. And they do that because they believe that if it's done by that mechanism, Tupe won't apply. The administrator expresses doubt, so HKL take advice. Now, ordinarily, if there's a transfer, regulations 4 and 7 are going to apply. So regulations 4 affect the transfer of the employees and their contracts that would move, and regulation 7, of course, prevents automatic unfair dismissals. Regulation 8.7, however, provides as follows, that regulations 4 and 7 do not apply to any relevant transfer, where the transferor, so that is in this case HKL, is the subject of bankruptcy proceedings or any analogous insolvency proceedings which have been instituted with a view to the liquidation of the assets of the transferor and are under the supervision of an insolvency practitioner. Now, there's no doubt an administrator would be an insolvency practitioner. The question is whether administration satisfies the remainder of that test. Now, this was first grappled with in the case of Oakland in 2009. That was a case on similar facts. It involved a pre-pack sale implemented through an administrator. Now, the EAT picked out that an administration has several purposes, 3 in fact, one of which is the liquidation of the assets for the benefit of the creditors. But that's not necessarily the purpose of administration, and indeed an administrator is free to come into a business and consider its options before deciding upon its purpose. So what the EAT concluded was this was a question of fact, and therefore it was open to the tribunal to have concluded that on the facts regulation 8.7 applied, and therefore it didn't give rise to a Tupe transfer, or at least regulations 4 and 7 did not apply. Now, the Court of Appeal dealt with this case and concluded that the appeal should be upheld, but not on the basis of the Regulation 8.7 point, but rather on the basis of other issues, including continuity of service. So the issue at that point remained that Regulation 8.7 could apply to administration on its facts. We then had the case of OTG Limited and Bark in 2011. And that identified that there was this grapple between a fact-based approach that had been set out in Oakland and an absolute approach, i.e. administration is either absolutely within or without the scope of Regulation 8.7. And the EAT concluded that ultimately the purpose, or at least the chief architecture of administration, was a, quote, rescue culture, and therefore it does not sit with the purpose of Regulation 8.7. And indeed, one can beg the question, why ought a business sale implemented through an administrator to another business that can then carry on be any different to a sale that achieves exactly the same but outside an administrator, particularly in the context of a pre-pack where the sale was lined up before the administrator was brought in. This went on to the Court of Appeal with the allied case of Key 2 Law. OTG didn't go on, but Key 2 Law did, and the Court of Appeal upheld that decision. And so as things stood as at 2011, back end, I think the decision was December 2011, that was the position, that Regulation 8.7 did not capture administration at all. But let's look forward a little bit. Is, for at first, Key 2 Law the final word? Well, it's a decision that's now over 7 years old, in fact, no, 8 years old, and we are in a different environment. We're post-Brexit, we're post-COVID outbreak, and perhaps a different perspective would be brought were this reviewed again. Of course, Key 2 Law being a decision of the Court of Appeal, this would need to go all the way up to the Supreme Court. But if anyone wanted to challenge it, certainly if there was a business large enough that it was important enough, you can see how that might be challenged. Of course, if we're advising businesses, we're going to have to say, as the administrator did, we need to cast doubt on whether you can have a pre-pack administration that would engage Regulation 8.7. And certainly the received wisdom and much of the commentary on Key 2 Law over the last 3 years has supported the proposition that it is correct in law. But it's not necessarily the end of the road. And the reason that I say that is that the purpose of trying to circumvent the full effects of Tupe in this context for HKL is to maximize its sale value and to create as much flexibility as possible. Much was the case in the Brooks and Borough Care Services case. And ultimately, it may well be that NewCo still requires employees, but they want to be a bit more flexible on the terms that they engage those employees. Well, of course, ordinarily, they wouldn't be able to change the terms and conditions if the reason for doing so was the transfer. But Regulation 9 allows a NewCo to change terms and conditions in an insolvency scenario as one possible exception. Of course, there are other exceptions. For example, if there's an ETO reason entailing a change in the workforce. But as we know, the chances of a NewCo being able to establish that absent redundancies is pretty slim, practically nil. And so Regulation 9 may provide the alternative. Of course, the question is going to be, if Regulation 9 is outside the scope of Regulation 8.7, is it also outside the scope of Regulation 9? Well, first of all, there's a difference in terminology as between Regulation 8.7 and Regulation 9, principally the purpose being to liquidate the assets. But also, I've not found any case that's identified the difference between Regulation 8.7 and 9, certainly since the Key 2 Law decision. So it's open to businesses to argue that Regulation 9 is wider and that whilst the employees will transfer, NewCo is at liberty, or at least has a greater opportunity for changing those terms and conditions if they need to. Now, ultimately, HKL find themselves in a situation where they don't press forward with the administration and decide that they can't realistically achieve a sale of the business, and they're now looking at liquidation. Well, we really need to kind of pick up on a number of things, particularly if we're acting for employees in this scenario. So the first thing is anything that's going to be sold by way of this liquidation, either on its facts is unlikely to trigger a Tupe transfer if it's just a liquidation of various bits and pieces of the assets, or indeed if there's any undertaking that's transferred wholesale, well, it may well be that Regulation 8.7 precludes Tupe from applying. So in which case, the employees, like any others, are going to be debtors in that liquidation. Now, to the extent that any part of their debt is payable by way of remuneration, some of that will be treated as a preferred debt in the liquidation. And of course, if we're acting for employees, we're going to want to identify how much of that debt is preferred to ensure that they get as much of it from the liquidation as possible. Of course, that part that isn't covered by a preferred debt may be treated as guaranteed debts and payable by the National Insurance Fund. For example, the statutory redundancy payments, certain other guaranteed payments, and unpaid pension contributions. And lastly, to the extent that any SMP or SSP is not payable because the business is insolvent and unable to meet that obligation, that'll be picked up by HMRC. I hope that's been useful. I hope that's prompted some food for thought. That's generally the purpose of this section of the talk. Of course, we're now open to Q&A. You can either unmute your microphones and have a bit of a chat with us, or if you'd prefer, you can access the chat function by wiggling your mouse and clicking on the little speech bubble. Throw those questions out to us, and Nick and I will do our best to help you. Thank you very much.
I suspect with this good weather, you're likely to be hankering after your first lager and getting out in the back garden. I suppose that's quite conceivable. I wouldn't dream of thinking along those lines myself. Would you, Al?
I'm going to rush down and grab one in a minute. Sorry.
So the other piece of good news is that my mother, who's turned 90 today, had been diagnosed 2.5 weeks ago with COVID-19. She is bedridden, she's had a stroke, and she has diabetes, and her odds of survival I would have thought were pretty low. It's been a pretty stressful 2.5 weeks. Anyway, she's made it, and so she got to her 90th, which none of us thought was going to happen. So I shall be raising a toast to her very shortly. But
Mr. Smith.
Thank you. And do any of you have any issues you'd like to talk to us about? Hang on, I can see there must be a chat comment coming in. Let's see if we've got one.
Kathy, the group decides to put a subsidiary company into administration.
Yeah.
Or for some reason I can't see the end of your question. Oh, there we are. Does the employee have a claim against group, or is that associated company? I mean, it would depend upon the context, and it would depend upon, for example, whether they do any work for the other subsidiaries, whether that may have triggered, or in that case, the parent company, whether there's been a transfer. But ultimately, if it's just a pure subsidiary relationship, then no, there's not likely to be any claim against the parent company, because they're just shareholders. Shareholders are going to have limited liability, just as any other individual shareholder would. It won't change the relationship just because that shareholder happens to be a corporate shareholder. So unless there's some dynamic that triggers or has triggered a transfer as between the group companies, simply the fact that a subsidiary has a debt to an employee, it's not likely to be something that the group company is going to have to pick up. Again, the alternative perhaps is where you might argue that you should be able to pierce the corporate veil, because in reality this is one company. Then that might give rise to an issue. I know a lot of companies now are effectively creating a separate company that just has all of their employees and it doesn't trade. You may well say that if it's a pure division in that scenario, you might have grounds to pierce the corporate veil, or you might have grounds to say that actually there is an assignment issue. So I hope that answers your question.
Looks like it does. Well done. Okay. Look, what we don't want to do is keep you hanging on thinking of clever questions to ask us at this stage of the game. If you do have any matters that you need to discuss or would like some views on, drop us an email, and we can always get back to you later in the week. But let's just hope that whether it be Al or my side of the talks this afternoon, that you feel, you know, at least, if maybe at the very least, a bit of rust remover has been applied here. I sincerely hope that's the case. And I think, regrettably for society, us employment lawyers are probably going to be quite busy. But anyway, I see Heather's saying not all of us in a sunny garden. I hope you get back to one, Heather. I think this is a really good bit of weather tonight. So there we go. Let's hope you all enjoy your evening. And I look forward to seeing you, hopefully person to person, later in the year when we have our annual seminar in Bristol. And one of the things that's come to light, I suppose, with the new modus of communication and the broad reach of webinars, is that might not necessarily be necessary. But I can't see how we can give you a virtual glass of wine or a very nice vol au vent. Who knows? Maybe we can even think of that. But all the very best, and we'll speak to you soon, hopefully.
Maybe that's something that we could diversify into.
Yeah, maybe yes, exactly. Your special nibbles company can diversify supplying virtual webinar attendees with drinks and nibbles. Who knows?
Lots of thank yous, and indeed thank you to you guys for attending, particularly this late in the day when it's a sunny afternoon, and I'm sure you might think that being outside is better than being with us, but good to see you all in a virtual sense at least.
Yeah. Brilliant. Thank you. Employment Judge Battersby on there as well, which is very nice to see. All right. Well, we'll hang on for a minute or two, just in case there are any last minute thoughts. Otherwise, see you when we see you.
Incidentally, if anyone does happen to think of a clever question later in the day, the chat window in fact stays open. So if you do go and have a glass of wine and have a light bulb moment, do still come back to the chat if you want us to answer it. Alternatively, you can grab our emails off the website. I'll put them in the chat window. Email Nick or I, and we'll do our best to help you.
Cheers, Rory. Thanks for your comment. Yeah, I'm looking forward to having a Skype face-to-face my mother in about 10 minutes. So let's look forward to that. Right then, I think I'm going to call that time.
Yes.
Thank you very much. Anyone's left, sadly waiting in the wings, we're going to call it time. Let us know if you need to speak to us later on. All the very best. Thanks very much, Al.
Take care, everyone. Take care, Nick.
Bye. Bye-bye.